Good morning, everybody. A very warm welcome to our webinar today on managing cash flow in a crisis. So thank you all for joining. My name is Stephen James. I'm a partner in the construction team at Clark's Legal. I focus on dispute resolution. I'm delighted to be joined today by my colleagues Ruth Wilkinson and Russell Dan. We have three presentations for you today. Next slide, please. So the first one, Ruth will be kicking off with a masterclass on payment notices. I'll then say a few words about termination in contracts, particularly from the employer's perspective, and then talking about how the landscape's changed as a result of the Corporate Governance and Insolvency Act 2020 that was introduced following the pandemic. Russell will be finishing our formal presentation with a session on the job support scheme, which comes into force on 1st November. We're very happy to take questions. We have time to cover those at the end. So if you submit anything through the chat box, and we'll cover as many as we can. Next slide, please. So before we get on to Ruth, just a couple of words by way of context. Of course, the construction sector is always subject to financial stresses, and the official insolvency statistics that are published show a good chunk of the sector, a good chunk of the overall insolvencies that come from the construction sector. The ONS publish construction-specific statistics. They show sustained periods of negative growth in the last 3 or 4 years, and of course everything fell off a cliff in March when there was the general shutdown. The most recent ONS figures are published up to August this year. They show, from a positive perspective, they show 3 months of sustained growth, unfortunately coming from a very low base, and currently we're about 10% below the levels we were in February on average. And that changes across the type of work we're concerned with. Infrastructures is now about at February levels. That's easier for the government to pump work into, whereas private industrial construction work is 41% below where we were in February. Of course, this is without saying anything about the B word and Brexit. We don't know where we will be in terms of a deal or any deal at all. I think what we can safely say is that the current free flow of goods, services and labour will end, and any deal will be quite limited, and that's at the very least going to bring a quite short, sharp additional shock to the sector. Next slide, please. I don't have time to talk about these today, but there are 3 interesting publications that recently been published by the Construction Leadership Council, and I recommend these if anyone wants to look them out. There's a statement on building winter resilience. The Roadmap to Recovery is a document that's published earlier in the year by the CLC, and there's a status report showing how things are getting on and where we should be going with all these issues. And also some guidance about Brexit and the implications for migrant labour. So movement of people, what should we be doing now? So I do recommend those if you want to have a look. Next slide, please. So I'm going to hand over to Ruth, who's going to be talking to us about payment notices.
Thank you very much, Stephen. I think it's fair to say that payment continues to be a significant issue for the construction industry, as it has been for many, many years, if not the #1 issue. And what I think will be helpful to do to kick off this webinar dealing with issues about cash flow is to give a quick reminder of payment, payless and default payment notices. A system of notices that have been in place since the amendments to the Construction Act that took effect in 2011, and despite them having been in place for kind of over 9 years, I still see today issues and a lack of understanding in the sector about what those notices are, what they need to contain. I'm hoping to set out some tips in relation to good practice, getting those notices right, and then of course what if you get it wrong. And of course, as many of you know, the consequences are very severe. You can be required to pay the sum in the contractor's application for payment or the default payment notice. And of course, as a payer, you may have significant issues with the amount that has been claimed. So this first slide that we're on now looks at payment notices and just sets out in brief the requirements of Section 110A of the Construction Act. As many of you should know, the Construction Act requires a construction contract to include an adequate mechanism for payment, which is to include both a due date for payment and also a final date for payment, and the parties are free to agree those. A payment notice has to be issued no later than 5 days after the payment due date, and the Act goes on to require that the payment notice has a particular content. It has to say that the sum that the person is giving the notice, so that the payer, who can be the payer or the specified person, or in some circumstances the payee, depending on the contract, considers to be or have been due as at the payment due date, and the basis on that sum, on which that sum has been calculated. And this information is crucial to have a valid payment notice. There's a note on the slide to remind people that a payment notice has to be given even if the sum that's to be paid is 0. Next slide, please. So the next slide talks about the default payment notice, and this was introduced by the amendments to the Act. And this means that in the absence of a payment notice, so if the payer is late in issuing that payment notice, the payee can issue its own notice called a default payment notice at any time, which can set out the notified sum, the sum that it considers is due to it. The same requirements as a payment notice apply, so the requirements as to the sum that they consider is due as of the payment due date and the basis on which that sum is calculated. Now, as many of you will be aware, some of the standard form of contracts already provide for an application for payment. So, for example, the JCT Design and Build contract, the 2016 edition, already requires that an application for payment has to be given by the contractor. And it goes on to provide that that application for payment can be the default payment notice. I think it's important to note that for contractors, that if they are preparing an application for payment, that they will be wise to ensure that they include the relevant information that would satisfy the requirements of a payment notice. And if the contract doesn't provide for an application for payment in that way and they have to issue a default payment notice, it's critical that it includes that information. There's a quick note on the slide about the delay to the final date for payment, and that's just a reminder that in the event that a default payment notice is issued and it's not the original application for payment, then it's imperative to try and get that payment notice in as quickly as possible after the period for the payment notice has expired, so that 5-day period from the due date, because the knock-on effect is that it will push out the final date for payment by the same number of days. Next slide, please. So Section 111 of the Act relates to the Payless Notice, and this is the section that sets out very clearly that the payer must pay the notified sum. That's the sum stated in the payment notice or the default payment notice, subject to any Payless Notice by the final date for payment. And it also sets out what the Payless Notice has to include. So it's the sum that the payer considers to be due on the date of the Payless Notice. So note that it's a different date to the due date, much later in time, and also set out the basis on which that sum has been calculated. Now, it's been confirmed by the courts that a Payless Notice can both set out cross-claims, so for example, in relation to defective works and liquidated damages, but it can also be an opportunity for the employer to give a different valuation, so a second bite of the cherry in relation to the valuation of the account. So of course, we're looking now at the date of the Payless Notice rather than the date of the due date. Now, the Payless Notice can't be given before the payment notice. And then in terms of the timing, the parties are free to agree the timing of the Payless Notice. If they're unable to agree or the contract doesn't provide, then the scheme provides for a period of 7 days before the final date for payment. The standard position in the JCT is 5 days before the final date for payment, but I have seen contracts amended so it can be as little as 1 day. And again, the Payless Notice is required even if the sum to be paid is 0. Next slide, please. So you've got your note, hopefully the notices have been issued, that there's been a valid payment notice. When it comes to looking at, obviously one of the significant issues that I see regularly is the validity of those notices, and particularly the validity of a Payless Notice. And we've got issues in relation to the timing of that notice, and of course it has to be issued within the requisite time frame. But in terms of the content of the Payless Notice, that's quite important. And the case of Rove and S&T back in 2018 confirmed that there were 3 rules in terms of whether that Payless Notice was valid, and they're set out on the slide. So the first one is, how would a reasonable recipient have understood the notices? And that effectively is saying that you would take into account the background, the context in which that notice was given, and the objective intention. By way of example, an employer's markup of an initial valuation was not a valid Payless Notice. That was one particular case. The courts have made it very clear that they're not going to be impressed by artificial and contrived arguments on a technical basis, that they will try and take a common sense view. And the final kind of test really is, would the notice provide an adequate agenda for the adjudication, for a potential adjudication? Would it give sufficient information for the parties to understand and adjudicators to understand what the basic valuation was and any cross claims? Next slide, please. So I thought, given that this is a webinar about trying to manage your cash flow and looking and assessing that risk, I thought I'd kind of give some thought to some practical points and some tips in terms of trying to get the notices right in the first place. And I suppose the starting point, it's always better to get it right than to deal with the consequences if it goes wrong. And the first point, as always, is to check the terms of the contract. As I mentioned at the outset, the Construction Act requires that the construction contract includes an adequate mechanism for payment, so it includes this due date, this final date for payment. You need to consider whether or not there is an adequate mechanism for payment. If there isn't, and the payment provisions are deficient and don't include the requirements of the Construction Act, so the requirements for payment notice and Payless Notice, etc., then the scheme will apply, but the scheme will only apply to plug the gaps. It won't apply wholesale. A couple of points also in relation to the contract. I know that it's been quite common practice for the final date of payment to be tied to the issue of an invoice. There was a recent case that indicated as part of the auditor that invoices tying the final date of payment to the issue of an invoice wasn't an adequate mechanism for payment. And that's something that we're expected to see more issues with coming forward. The next bullet point is to look at the timing and the dates very carefully, so to work out exactly when these notices need to be issued. It's crucial to get the notices in on time, otherwise they will be invalid. I've seen errors recently in the calculation by a contract administrator of the payment dates and payment notices, because they have assumed that the dates were calculated on the basis of working days rather than calendar days. And of course, when you're looking at payment notices, the usual position is it's calendar days. Of course, although you can take into account bank holidays, so you need to look really carefully at what the contract says about the calculation of days, because that can make quite a significant difference. And you can those notices can be issued late. I suppose the other point to come back to in terms of the timing and dates, there was a case quite a few years ago now where the parties had agreed a schedule of payment dates. The works were delayed, not unusual in our sector unfortunately, and the schedule of dates ran out. And the parties went off to the court, and the contractor, I think, was trying to ask for a term to be implied into the contract that additional dates will be added onto that schedule, and the court said no, that's the bargain that you've made. So the other point is, if you are wanting to include a schedule of dates, you need to make sure that it either goes on for long enough, or alternatively includes wording that means that if the works are late, that interim payments, for example, will continue on a monthly basis on a particular date. The third point that I thought would be quite helpful was in relation to the Payless Notice. There's no specific requirements in terms of the format that notice needs to take, although obviously the content is quite important. But I think it's always helpful, if you are sending a notice out, that it's clearly labelled as such. So call that notice a Payless Notice, perhaps refer to the specific sections of the contract or the sections of the Act. Because I think the clearer that you can be at the outset, the better, because whilst some of the cases may help you and say, well, actually, I'm looking at this notice objectively, it was a Payless Notice. I think once you start to get into that territory, you're on shaky ground and you can't with any certainty predict the outcome. The fourth point is a reminder to make sure that you include in that Payless Notice the notified sum, so the sum that's going to be paid, and also set out your reasons and calculations. There needs to be a summary of that calculation and perhaps supported by an Excel spreadsheet that should be attached to it. I think it's better to avoid referring to other documents that are not provided with the Payless Notice. So, for example, in the Grove and S&T case, the Payless Notice referred to a schedule that had been attached to the invalid payment notice. And whilst in that case that was permitted, again, you can't guarantee the same outcome. So I think you need to get your ducks in order and make sure that all the documents are there and contained as part of that notice. The final point is whether or not negative amounts are permitted in a notice, in a payment notice or a Payless Notice. And I think the general thinking at the moment is that the Construction Act does allow for a negative sum. The issue might be whether that sum can be claimed by you as the payer, and that depends very much on the terms of the contract, whether you've got a contractual right to enforce that and to get that back. In any event, I think if you are going to include a negative sum, I think you need to be clearly about actually whether that is the notified sum or whether the notified sum in fact should be zero. Something else to consider. Next slide, please. So, despite your best efforts, it's gone wrong. The notices were either late, they didn't have the right content. In any event, what are the consequences of that? Well, it's fair to say the costs of getting it wrong are pretty high. And since the case of S&T and Grove in 2018, which went to the Court of Appeal, it's very clear that a paying party must pay the notified sum. So that notified sum, if we go back to section 111, is the sum stated in either the payment notice or the Payless Notice, sorry, or the default payment notice, subject to any Payless Notice. And the paying party may subsequently, so not until after it's paid that amount, may commence adjudication or court proceedings to determine the true value of the account. And we are seeing that's what contractors that are sitting on this situation are doing, contractors that haven't had a Payless Notice. We're seeing either threats of adjudication or alternatively letters of claim seeking recovery of that money as a debt. And you know, the challenge for us advising our clients is if they haven't got those notices, our position is very difficult indeed. What I've tried to do on this slide is to summarise some of the kind of more recent cases that have kind of built on S&T and Grove and developed that rule. So, for example, the Davenport and Greer case, which was published last year, that confirmed that the Construction Act creates this immediate payment obligation. That money has to be paid, and this right to cash flow kind of trumps the right to adjudication. Another case, Broseley London versus Prime Asset Management, which was this year, that clarified and confirmed that the paying party wasn't entitled to start the true value adjudication until such time it pays the notified sum. Another case, J&B Hopkins versus Trans Engineering, this confirmed that the employer couldn't argue in enforcement proceedings that because the amount that was claimed, the amount that was the subject of the adjudicator's decision that had been won, was pursuant to an earlier interim payment, and now that overpayment had been rectified in later assessments. That meant that they now weren't entitled to recover that money, and the court said no, still entitled to recover the money that they got under the adjudication. And I think the final point is quite interesting really to employers as well, that the burdens on the employer, the burdens on that paying party to show that the contractor or the subcontractor has been overpaid in the event that they neglect to serve those notices, and that's from ICI and Merit. And that is because the burden is now to show that the adjudicator has got it wrong, rather than on the contractor to show that that was the final value of its works. And that, of course, will put a significant burden on the employer, and yet another reason why it's so important to get those notices right in the first place. So quite simply as it stands, if you don't issue a valid payment notice or a valid Payless Notice, you're exposing yourself to a real risk that you will be required to pay that notified sum. And I think it needs to be a really exceptional case in order to avoid enforcement, and we'll look at that. We'll look at that on the next slide. Next slide, please. So just a quick note about enforcement. So if the payee wins the adjudication, there's no valid payment or payless notice, it gets the sum awarded, it can go off to the Technology and Construction Court and seek enforcement of that adjudicated decision. And there's a special process in the Technology and Construction Court to get adjudicated decisions enforced. It's a very swift process. It lasts a matter of a few weeks. And as the payer, the paying party, in order to try and resist that enforcement, you have quite limited arguments in your arsenal. You would need to try and argue, for example, that there was lack of jurisdiction to hear the dispute by the adjudicator, or a breach of natural justice. In limited circumstances, you may be able to request a stay of execution, so that rather than getting immediate enforcement and be required to make that payment immediately, you get a period of stay that goes on hold while you can, for example, start proceedings in relation to the true value of the account. Now, the first bullet point confirms that the starting point really is that adjudicated decisions are very likely to be enforced, provided that the issue that was referred was decided and the adjudicator broadly acted in accordance with the rules of natural justice. And this goes back to the key issue that adjudication is an interim binding form of dispute resolution, and it's open to the parties to go to either litigation or arbitration to get a full decision. There is a very limited exception, which was recognised in the case called Hutton a few years ago, where if there is an issue over the timing, categorisation and description of a payment or payless notice, provided that issue is very self-contained, it's possible that that could be a basis of resisting enforcement. And in these circumstances, you would need, as the paying party, to be looking to start Part 8 proceedings to look at that particular issue. So they're looking at the discrete issues in relation to those notices. However, I imagine that the exception is very limited indeed, because the judge in that case said that in 99 out of 100 cases, he doesn't think that this will be an obstacle to enforcement. And the final point I just wanted to flag was that there may be a stay of execution in very limited circumstances if the payee wouldn't be able to repay the sum. And I think Stephen might be touching on this a little bit more when he talks about insolvency. But this, in circumstances where, as the payer, you paid that sum, but you had real valid concerns and evidence that the payee would not be able to repay that sum if you subsequently went to full litigation and you were successful, then you may get a stay of execution. And in this particular recent case of JRT Developments and TW Dixon, that's exactly what happened. The judge in that case decided that there was a real risk that if that money was paid over to the payee, it wouldn't be repaid in the event that the payer subsequently won on the valuation, and also that it would be manifestly unjust to the paying party. And in this case, it was very significant that if the payer paid that money over to the payee, he wouldn't have the funds and resources available to be able to pursue the true valuation, because they themselves would risk being put into an insolvency situation. And there were also specific and unusual facts about that case, including criticism of the tactics that had been employed by the party expecting payment. So again, very, very exceptional circumstances. And I think that's what these cases are illustrating, that the most vital important thing is to get those notices right in the first place, to avoid being in a situation where you're scrabbling around trying to find an argument, trying to find a basis on which you don't have to pay those monies. And I think the last point I will probably make is that in relation to claims that we're seeing at the moment, where we are seeing a failure to provide a valid payment or a payless notice, and we've seen contractors trying to capitalise on that. The issue that the employers have is quite often they don't have the money to be able to either defend the claim or alternatively to actually pay the amount that's being claimed, and then they're forced kind of over a barrel in terms of trying to negotiate a deal with their contractor, which is unlikely to be the outcome that the employer would have ideally wanted. Anyway, that's me, so I'm going to hand back over to Stephen. Thank you very much.
Thanks, Ruth. Right, as I said, I'll be talking about some termination issues, and particularly the Corporate Governance and Insolvency Act. Next slide, please. So there are two sections to my part of the talk. Firstly, from an employer's perspective, in practical terms, what are the warning signs you might see on site, and what things should you and should you not be doing if you spot those warning signs? And then from the contractor's side of the coin, how the Corporate Governance Insolvency Act has impacted on the right to terminate and what to be aware of. Next slide, please. So just in terms of what you might be seeing on site if things aren't going so well, and question whether these are issues of simply poor management or are they a symptom of some more underlying financial issue with the contractor, and does that mean that insolvency is possibly on the way? Sorry, it's just gone out in here. I think you can still see me. There might be a lack of progress on site. The contractor might not be hitting the milestones that it should be. The labour on site might not be what it should be. There could be a high turnover. There might be a general decrease in labour. Work might not be as good as it should be. It could be some defects that are being picked up by the contract administrator. Is the contractor adequately delivering materials to the site, in fact, removing plants and materials from site? Okay, next slide, please. And things that you might, sorry, one of the flaws of a modern office, if you sit still too long, the light goes off, so just move and make it come back on. Other than being physically what you can see on site, doing a bit of financial due diligence, it's easy to register a company's house to get updates on any filings for the company. Are the contractor's accounts late? Has it filed anything that that gives cause for concern of new charges, for example? Is the contractor asking for payments ahead of what the contract provides for? Is it putting in claims that are clearly inflated? And subcontractors coming to you and asking for payment directly because they haven't been paid. Okay, next slide, please. So what do you do as an employer in that situation? Well, I think the general message is to have a clear contingency plan, so you're ready to spring into action in case things go completely wrong and perhaps the contractor enters some sort of insolvency procedure or leave site or whatever. So the first is to be aware of what your contractual rights are. Can you terminate? In what circumstances can you terminate? Do you have rights to step in and complete the works? It's important to get on top of what these rights are quickly, because if you have a right to do something that might be time limited, in practical terms, it may be very important to take action quickly. You might need to put your remedial steps in place in the background. If collateral warranties are to be granted or given under the contract by other subcontractors or other consultants, are they in place now? From my experience, it is much easier to get those at an early stage. It's very difficult to get them once the contractor goes bust and you go to third parties who've got no real incentive to comply with you. If you've paid for any materials up front, are they clearly labelled as yours? There can be a lot of confusion if there's an insolvency takes place, and a bit of a bun fight as to who owns what. If you can identify stuff as being paid for by the employer and legally owned by the employer, that will certainly assist. Who are the key subcontractors? Who are the ones you would need to keep on board for the job to continue if the contract goes past? And finally, to make sure you have a clear record of what's been done and what the value of that work is. There'll be a reckoning up of if the contractor becomes insolvent, to reckon up the value of the work's been done. That's always much easier to assess if full records are being kept contemporaneously. Working everything out weeks or months or years later is fraught with difficulty. Okay, next slide, please. So what shouldn't you do in these circumstances? Well, the risky thing is to immediately terminate. And the reason for this is if a party seeks to terminate a contract, but they don't actually have the right to do so, that in itself puts that party in breach of contract. The other party, the one who's really in the wrong, can seize on that and say, oh, actually, you're breaking the contract. I'm going to accept your breach of contract. I'm going to bring the contract to an end. And that can have significant implications when the court comes to award damages. And in general terms, the employer will be in a much better position if it can show that it terminated the contract by reason of the contractor's breach, rather than messing things up, allowing the contractor to bring the contract to an end, and then possibly go on to claim loss of profit on the remainder of the job. Paying a subcontractor, there may be practical reason why you need to pay a subcontractor to get them to stay on site. The risk is you end up paying twice, because the legal obligation is to pay under the contract, pay the contractor under the contract. If you don't pay the contractor, then you haven't discharged that legal obligation, you haven't discharged that debt. And the fact that you paid someone else is sort of neither here nor there, and the contractor can still come to you and demand payment. In those circumstances, the contractor may recognise that you need to pay the subcontractor directly, and if that cannot be recorded, and an acknowledgement that making that direct payment to the subcontractor means that the sum you owe to the contractor is reduced accordingly, and you ought to avoid those difficulties. Ideally, would avoid paying in advance for materials. Again, sometimes this is something you simply can't avoid. It's a necessary part of the job. It's important to be aware of what the default position is in terms of payment and delivery of goods. The legal ownership of goods passes over when the goods are delivered, not when they're paid for. That's the default position. So if you pay for something up front, but you don't actually physically have it yet, you don't own it yet. This can be overcome by what we call vesting certificates. So it's acknowledged that the legal ownership of whatever you paid for belongs to you when you pay for it. And don't rush in and appoint a replacement contractor. This is really linked to the first point. Doing so would potentially put you in breach of contract with the original contractor, give the right to the original contractor to terminate the contract, and they will end up in a much better position than they should be as a result. Okay, next slide, please. So the Corporate Governance and Insolvency Act 2020, this is quite an interesting piece of legislation. It was brought in pretty short notice. It went through Parliament quite quickly, and it's a hodgepodge really of provisions that the government had in mind to introduce for some time, but just hadn't got around to it yet, and also some temporary measures to grant some temporary relief as a result of the pandemic. Examples for temporary measures might be that the wrongful trading provisions were suspended until the end of September. That suspension has now come to an end. There was a prohibition on issuing a winding-up petition based on the statutory demands. That prohibition has been extended now until the end of the year. But some of the provisions are permanent. This is a permanent one. It's Section 14 of the Corporate Governance and Insolvency Act introduced a new section to the Insolvency Act. It's 233B. Section 233 was always there, and it prevents suppliers of essential services, typically utilities we're talking about, from turning off the supply if their customer enters an insolvency procedure. What 233B does is extend that to all suppliers of all goods and services, apart from financial services. So it's not something that's limited to the construction sector, but it certainly applies to the construction sector. And as I say, this is from a contractor's perspective. It's not from the employer. The employer's right to terminate will be unaffected. So what does it mean? The employer enters liquidation, administration, etc. The contract might provide that that it terminates automatically on that insolvency event. Well, that doesn't happen anymore. The Section 233B means that doesn't take place. You might have a right to terminate in those circumstances. Again, you can't exercise that right just because they're now in an insolvency. You might have a right to terminate that existed before the insolvency started. It might be that there's a non-payment and that gives a right to terminate. If you haven't exercised that right before the insolvency started, it's too late. You can't exercise anymore. So you've got to continue with the supplier. And the final thing you can't do is say what you might want to do. Say, okay, we'll continue with this contract, but you've got to bring the account up to date first. We've got some outstanding debts, and we're not doing anything unless you pay us. Again, you can't do that. You have to. You can't make that condition as a condition of continuing the contract. There is a question mark at the moment. I can't give you a straight answer on this. Do you have the right to suspend? Under the Construction Act, there's a right to suspend in all contracts in the event of non-payment. It's not clear. Unfortunately, the Corporate Governance and Consulting Act doesn't cover this expressly, and the explanatory notes didn't give an answer either. And legal commentators are kind of scratching their heads at the moment and seeing, because you have two statutes that say different things. One says you can suspend in non-payment, the other says you can't. So we'll have to wait until this comes before the court and you have a definitive answer on it. Okay, next slide, please. So Section 233B has some exceptions. The first one is actually a temporary exception. This applies until I think March next year. Again, it might be suspended. It might be extended, I suppose. If the supplier, the contractor, can satisfy three of these criteria. Sorry, two of these three criteria. They have an average turnover of less than £850,000 a month, and that equates to about £10 million a year. They have an aggregate balance sheet of under £5.1 million, and they employ fewer than 50 people. Then you'll be exempt from this. You'd still have the right to terminate. As I say, but again, this is a temporary provision, will expire next year. If the parties consent, it might well be that the company enters insolvency. The office holder who's appointed recognises there's no point continuing the contract and wants to bring it to an end immediately, so they can agree, the parties can agree to terminate the contract, no problem. And there's a possibility that if you demonstrate hardship, the contractor can demonstrate that having to continue with the contract would cause hardship. They may be excused. Again, we don't have any particular guidance about what hardship means. I'd suggest it's got to be fairly extreme hardship, because the whole point of the Act is that you're not allowed to terminate generally, and it recognises that you might have some historic debts that won't give you the right to terminate. So the hardship will have to be at a fairly high level. It's not all completely bad news for the contractor, and this is following on from the process that we had in the original Section 233. If you continue the contract, you're entitled to be paid for work that's done during the insolvency, and that is paid as an expense of the insolvency. There's a statutory pecking order in which assets are paid out, and this is paid pretty much near the top. So the chances are, if you're asked to continue the contract, there's a very good chance you will be paid for it. And if you're not then paid, you will have the right to terminate. You can bring things to an end. Okay, next slide, please. So just to sort of wrap up my section, what else can you do to chase payments? Well, statutory demands are something that historically can be served for an undisputed debt. and there's no counterclaim that would net off the amount that's payable. At the moment, under the Corporate Insolvency, sort of Corporate Governance and Insolvency Act, a winding up petition cannot be based on a statutory demand. So you could serve one, and you might scare someone into paying potentially, but if they know the law, they know that you can't take it any further in terms of winding up petition. So it's a sort of legally pretty pointless thing to do. However, that only applies to companies. If you're dealing with an individual, you can still serve a statutory demand and follow that with a bankruptcy petition. There's no prohibition on that. There's also the Act, in theory, allows for the presentation of a winding up petition that's based on a debt that is not the result of COVID, or the inability to pay is not the result of COVID. In practical terms, I'd suggest it's a pretty much impossible job proving that, both because you have to sort of prove the negative, and also in terms of the process that's been set up to get this through the courts, it's just not going to happen. So winding up petitions are pretty much off the table for the time being. The good news is that adjudication continues pretty much unaffected by the change in our working practices over the last 6 or 7 months. Adjudication has always been very much a remote process. It lends itself very easily to everything being done electronically by Teams meetings or Zoom meetings if required. And from my experience, I've had no difficulties at all in the adjudications I've run as a result of COVID restrictions. Talking is, as ever, always best. It leaves aside all of these uncertainties, and if you can agree things, then that's so much better. Along with adjudication, the courts continue to run. They operate remotely. There are very few in-person hearings, but to be honest, that's viewed as quite positive, actually. For people attending these hearings, there's a lot less waiting around, a lot less fuss. Electronic filing, so the court proceedings are operating fine, and I wouldn't have any particular concerns about issuing court proceedings at the moment if you need to. Okay, that brings my section to an end, so I'm going to hand now to Russell to talk about the job support scheme.
Thanks, Stephen. Thanks, Ruth. Hopefully everyone can hear me. So in this part of the talk, I'll be talking about employment issues, and I'm using employment and employer, meaning your business as an employer of its employees, not in the construction sense. And this is really about internal cash flow matters. So what comes in next month and runs for 6 months is the option of using the job support scheme. Most people probably will have become familiar with the furlough scheme. This is the replacement to that. It's less generous to employees than the furlough scheme, that's the CJRS. On the other hand, businesses don't need to have previously used the CJRS to access this scheme. Either as a business, they can use this having never accessed the CJRS, and also in respect of any employee, it isn't tied to previous use of the CJRS. What employers have to do is pay employers' NICs and pension contributions in all cases. And it's also important for employers to realise that it can't be used for employees where they're on notice of redundancy. That's in contrast to the CJRS. So if you were thinking about extending someone who is currently on a furlough into the job support scheme, you'd have to bear in mind that if there's going to be a redundancy, then the whole redundancy period would have to be paid at their full pay level. Next slide, please. It's for employees who have been on payroll by 23rd of September 2020 at the latest. The minimum claim period is 7 days. It can be any 7 calendar day period, which might suit different working patterns. In terms of cash flow, we know for sure that it will be on a monthly basis in arrears, and the claims can't be submitted until December. So what this means is, were somebody on this scheme, an employee was placed on the scheme as of next week, 1st of November, then you would be paying a month and probably 2 months to them before any money comes back to the business. A very important point, aside from cash flow, but which really goes to risk, is consultation. Now, talking is always better, as Stephen and Ruth have said, and that this doubly applies when you're looking at your own employment relationships with your employees. Firstly, being open with employees about what the predicament of the business is the best way to get buy-in from them. But on a technical point of view, you have to consult. For larger employers, if you have a European or a national statutory works council, then failure to consult with that statutory forum will result, or very likely result, in large fines. There was a case a couple of weeks ago, not about JSS, but where an employer had to pay £35,000 in fines for trying to bypass internal mechanisms. They would have said at the time they were in a sort of distressed business situation, but the law says you must consult with the bodies that have been set up for consultation. Also, if the alternative to using JSS would be 20 or more redundancies at one workplace, i.e. if the employees don't agree, there's going to be 20 or more jobs on the line at their establishment, then again, you must consult. You must consult with reps. If there are not reps, you must elect reps. If you fail to consult and fail to elect reps, then you stand to a 90-day per employee maximum penalty, and that's paid at their 90 days of their actual pay, not at any statutory limit. Individually, you also need to consult if the alternative is redundancy. The alternative will not always be redundancy, but it will almost always be redundancy. You could argue that the alternative is reduced hours, but not a reduced need for people doing the work. That will be the subject of a technical discussion on redundancy. But our advice has got to be consult, get their employees' agreement and buy-in, have an open channel of communication with them. Most employees know why a business will be doing this. And then you need to notify employees in writing and keep a record of that notification. Next slide, please. There are two kinds of job support scheme. The first is called business closure JSS. This is for those businesses that have been legally required to close. So hospitality businesses in tier 3 parts of England, as we're now becoming familiar with them, any others that get added. In that case, any employer can use it, but it's expected that the employer that does use it won't be making capital distributions such as dividend payments. In that case, the government will pay 2/3 of employees' pay, capped at £2,100 per month. If an employee earns minimum wage, it doesn't have to be topped up to minimum wage, it's just 2/3 of their pay. That's somewhat familiar to employers who've used the furlough scheme, but the cap is £2,100 per month and it's 2/3, so it's 67% rather than 80%. Employers don't have to contribute, but do have to pay the national insurance and pension auto-enrolments. Next slide, please. Now, I'm going to spend most of what I'm talking to you about today, time-wise, on this one, because this is going to be more in the sector that's relevant to you. So short time working job support scheme. All SMEs can use this. It's only open to large employers if their turnover has fallen due to the pandemic. And again, the government expects they won't be making out distributions such as dividends. The definition here of large employers, the guidance was under the furlough scheme, the definition under the related scheme, the definition was 250 employees. So it's not the same thing as the small business exemption. The example that Stephen doesn't use it. The guidance on the JSS altogether is actually due out today, but as the second I started this talk, it hadn't yet been released. Next slide, please. So on this scheme, employers do have to contribute. Employees need to work at least 1/3 of their normal hours. They get paid in full for that. That leaves the remaining 2/3. That's divided into 3. 1/3 paid in full by the employer, 1/3 paid by the government, but with a cap of under £700 a month, and 1/3 unpaid. So if someone works 1/3 of their hours, the minimum, then they're getting paid in full for that from you, the employer. And then if the remaining 66%, you're paying 1/3. So in total, you would be paying 55% for someone doing 33% of their work, and you'd be paying the national insurance and pension on the amount, including the government's contribution. So that would be 77% for that minimum level. Next slide, please. An example of someone who works 5 days a week, if they agree to reduce to 2 days a week, so 40%, that's more than the minimum. If they're earning £500 a week normally, conveniently £100 a day, then they would, under the scheme, they would get £400, 80% in total. 200 for the 2 days they work, 100 from you for 1 day not worked, 100 from the government for 1 day not worked, and nothing for the final day. So that would be 80%. Next slide, please. The next slide shows us how it is geared towards, the cap means it's geared towards people who are not the highest earners. So again, someone here working 5 days a week, but they earn 1,000, so have doubled the figure. If they agree to 2 days a week under the scheme, then they don't get 80%, they get 76%. So looking at the bullet points, they get for the 2 days worked, £400. For the one of the days not worked, £200 from the employer. For the one of the other days not worked, £161 from the government. That's because the cap kicks in. The £200 a week is more than the government's cap of £697 a month, and then nothing for the remaining day. So in total, they get 76%. Next slide, please. So these are really the questions. Will it work for your business? I mean, firstly, will it work for your employees? You can see that it's less attractive to higher earners because they would inherently take a bigger hit if you're doing the minimum. It's also a question of the nature of your business. It would seem to be more geared towards businesses that have a good pipeline, but a temporary issue where their workforce is not the most highly paid, but is reasonably highly paid, and also is not cheap to replace. Now that will be some specialist businesses in construction, but perhaps not that many. The other factors to consider are if your employees have previously been furloughed, then there is an upside to retaining them until at least 31st of January. Well, retaining them and not giving them notice of redundancy till at least 31st of January next year, because if that is the case, then there will be a £1,000 job retention bonus. So you've got to add on the notice period, say 2 or 4 weeks from 31st of January for someone who's entitled to redundancy pay, and then think about how much you would have to pay under the scheme over the interim period of November, December, January to see whether the £1,000 bonus tips the balance. It will for some, it probably won't for most. The other alternatives are, is it a better idea simply not to use the scheme? Again, open channels of communication with employees via their reps, if that's applicable. Is it better to renegotiate terms and conditions? We're certainly seeing a lot more business interest in that currently than we were under the furlough scheme, and we infer that the reason is the JSS is less generous. Again, the same considerations do apply in terms of consultation with all of these alternative options. There is also the option of the consideration of layoff. Now, you can't just unilaterally lay off your employees, unlike, say, self-employed individuals who you don't have any obligation to provide work to. You can't simply tell them not to come in next week, you're not going to pay them. But again, if people can understand the financial pressures the business is under, they may prefer layoff temporarily as opposed to permanently reduced terms and conditions. And the final alternative is redundancy. Some businesses are just looking at this and seeing that delaying the inevitable is more costly. Nobody wants to make redundancies, but people need to look at the best way to protect their business, and it's not going to safeguard more jobs if you're putting extra cost on the business which you can't sustain by using a JSS which doesn't work for you, but it will work for some. Now, on all of these things, we await the guidance. The guidance is due to be published today. I'm reliably informed, but hasn't been published yet. But with that, of course, answer any questions as they come in, but I'll hand back over to Stephen. Thank you.
Thanks, Russell. Okay, we've got a couple of minutes left, so time for a couple of questions. The first one's for Ruth. So Ruth, if you could come back in.
Hello, yes. So the first question, do you want to read it, Stephen?
Yes, so the question here is it worth issuing a zero-sum payment notice each month after PC up until the final statement, even if it's for a zero sum?
And I think in relation to this, I think the position after practical completion will depend very much on what the construction contract says. So what it says about whether they continue and at what interval, because in some contracts they can continue, but every 2 months rather than every month. I think if you get an application for payment after practical completion and you do not consider that any further amount is due while you're considering the final account, then I think it would be sensible, yes, to issue a payment notice in the sum of zero. And of course, if there isn't an application for payment, but if there is a date for a payment notice and you neglect to issue one, and then of course you would need to wait and see whether you get a default payment notice, and then make sure that you get your payment less notice in. So remember that you've got these 2 bites of the cherry, the payment notice and then the pay less notice.
Thanks. And there's one for Russell as well. Russell, are you still with us? Great. Will the JSS apply to CIS workers?
No, it won't. It will apply to employees. So it's people who are on your payroll. CIS workers, it won't apply to.
Great.
Zero workers, yes.
Great. Okay. And one more whilst you're with us. Are you seeing many business contacting you and saying they're interested in the JSS and they're going to use it?
Interested, yes. A lot of people inquiring to see what it entails, but to be honest, more of them are having understood the costs, and unless they meet those quite narrow sort of parameters of the type of businesses I think it would be most suitable for, they're tending to use it to look at alternatives. Some of the interest comes from their employees sort of defensively raising, you can't make me redundant because of this JSS. So it's important for businesses to realise they don't have to use this, and they absolutely shouldn't be concerned in a legal sense that they're going to lose an unfair dismissal claim because they chose not to use the JSS. But mostly businesses are looking at alternatives to it because it isn't as generous as the previous scheme.
Okay, thanks so much. That pretty much brings us up to the end of the hour, so we'll leave it there. Thanks again for joining us. I hope you found it interesting. Our contact details are on the screen now, and if there's anything else that occurs to you, we'd all be delighted to have a chat separately. So thanks so much and goodbye.
Thank you.